Comes from a town called Battle Creek, Michigan. And when I first heard of that, I said, where is Battle Creek? Was some kind of a battle going on there? That there must be a creek there too, I suppose. Well, he'll tell you the story about that himself, I assume, as he's told us before. But I know one thing. This man is not afraid of a battle when he knows he's on the right side of things. He knows that he's standing up for the truth and justice and American people's rights. I've heard about him over a year ago, and this is the second time I've had the fortune of seeing him and getting to spend some time with him. And I plan to spend more time with him, get to know him some more. But this man has done a great job of organizing groups across the country to get educated about the law, about the United States Constitution, about the income tax, about the corruption in our government, and how we can organize and work together in our communities as individuals who are aware and active, take charge, and take our country back. Please help me give a warm hand of welcome to Mr. Chuck Conces.
Thank you, Freeman. I really appreciate that welcome. This has become a real pleasure for me. I was down in Atlanta in last fall, in November, at the Freedom Conference down in Atlanta, and it was really enjoyable. I want to make sure you can all hear me. I'm a little taller than the last speaker. I guess that's got to come up a little bit, huh? Or I've got to bend down or something. Can you get that for me? Please. Okay. Yeah. Well, I'm real pleased to be here, as I said, and I am Chuck Conces, chairman of the Lawmen organization. We have lawmen lawmen public interest groups formed in a number of states now. And as a public interest group, we have the interest in seeing that the laws are properly applied and that the judges properly do their job. Now, we're working on it, and it's not an easy job. I'm not going to kid anybody here. It's not an easy job, but we're making inroads, and we're getting things done. And the reason we're so effective is because we have certain standards that we go by, and our own self-imposed rules. One of our rules is we stick to our agenda. We're not a debating society. And a lot of people that join our groups think that, well, they go in and they come in with this argument and that argument. Everybody sits around, debates, eats, and then goes home and retreats. We don't do that. Okay, we have an agenda, and at our meetings we're supposed to be covering certain materials. Some of it's educational, but sometimes it's getting people knowledgeable in court procedures and how to file pro se lawsuits. Pro se is Latin for meaning for myself. For myself. So I'm standing in court for myself. Um, uh, we hear all the horror stories, and I can't tell you how disheartening it is for me to hear people saying that 98% of the tax cases, the guys get prosecuted and convicted. I can't tell you how disheartening that is to me. However, that's what I'm trying to overcome. And thankfully, in November, I had a visit from 3 gentlemen from the government at my home, and I talked to them for probably about a half hour outside. And then one was an FBI agent, a young man, Chris McInnes. He's a very nice young man. I asked the 3 of them, I says, I would like to file a criminal complaint with you. They're there serving a civil complaint on me, and I asked one of them, I say, I would like to file a criminal complaint. And the marshal said, well, I don't know if I have jurisdiction to take one right now. And I said, well, I turned to Chris McGinnis, I says, how about you? He said, yeah, I'll take it. I said, okay, well, give me your phone number and address, and I'll call you, and we'll set up an appointment. So the following week, myself and 3 other gentlemen went in and sat down with Mr. McGinnis and another FBI agent, and we started the education process on those gentlemen. We brought them in the Supreme Court rulings. We brought them in all kinds of violations of law. Like, for instance, when they seize bank accounts without a court order. That's a violation of law. The law is in 6332, paragraph C, I believe. And it says, subject to judicial process. Means it can't seize a bank account without judicial process. So anyway, it turned out quite well, and right now we have the FBI looking into cases against our charges against the operations managers of the IRS, and including Mark Everson, because he knows damn well what he's doing. And he knows damn well what these agents are doing. So anyway, I'm just trying to tell you some of the good news and what we're doing. The bad news, keeps rolling in. We just had a vote in Congress on the Patriot Act. And the Patriot Act was signed, and Bush will sign it, of course, because he wants to lock down this whole country. He wants to take away all of our freedoms. That's the president that we got. I'm ashamed to say that I was ever a Republican. I am absolutely ashamed that I would ever think that the Republicans, how could anybody be so stupid as to think the Republicans would preserve your rights? They're no better than the Democrats. I wish I could put it as funnily, as amusingly as Dave Von Kleist did. I wish I was as funny as Dave is. But we have our job to do. We have over 5,000 lawmen joined in our organization, and we have about 100 groups around the country that meet and are formed. And I depend on people in the groups to take leadership roles. That's one of the things we really teach, is what's going to be required of people to be leaders. I was talking to one gentleman here, and he says he's not a great public speaker, but you know what, he will be. He's taken a leadership role, and he'll come along, I guarantee you. there's a lot of people in our groups who have risen to the top of their group because they take a leadership role and they know enough to stick to the agenda. They know enough to educate the group and to stay out of the goofy stuff. That's one of our problems. We're such a fast-growing group. We get maybe 5 to 20 people joining every day around the country. And because of that, we get so many people coming in with all this baggage. They come in with baggage, and they say, I'm not a U.S. citizen, on and on and on. I mean, they've got so many things that they could never argue in court. Would never do them any bit of good in any way, and can get them in terrible trouble if they argue those things. I think as a result of the way people have done in the patriot groups, you know, where they come in and they argue these things, it becomes an endless argument in those groups. And they waste all their time just arguing about whether we have a common law system, whether we have, whether the 14th Amendment makes us a slave, all this kind of stuff. We just had another discussion yesterday on the United States versus the United States of America. Are they the same and one and the same entity? No. I see a gentleman smiling back there. I won't mention. But these are the kind of things that we really don't do in the groups. Now, I write papers, and if people will read the information that I've gathered and researched, then they can come to their own conclusions. But something like that particular issue, the United States of America. What is the United States of America? If, say, supposing you say, and I know a lot of patriots have come to this conclusion, that the United States of America is the 50 states, and the United States are the states outside of the 50 states, like Guam, Puerto Rico, Washington, D.C. I think it's just the opposite, and I think I could prove that. Okay, but if, say, supposing you get it just backwards, then aren't you all, in all your arguments in any court case, doesn't the judge look at you like you're a lunatic? See, if you have 10 arguments that you're using in court, and one of them is a goofy argument, they'll focus on that one argument. They won't even talk about your other 9 good arguments. So you really have to use, you have to be very, I would say, polished and knowledgeable when you go to court. Now, in federal court, it's different than if you're going into a local state court. Local state courts, you usually have to go in and go to a hearing. In federal court, it's almost all on paperwork. I do want to remind you all at this point, and I keep reminding people, I am not an attorney, and I do not give legal advice. I simply am telling you from my experience and my research what I'm doing and what I've learned. I'm trying to give you encouragement. I'm trying to educate people. I do classes to educate people. I did a class last summer. It was 23 hours. And it relieves a lot of problems for me, because then I don't have to keep repeating the same things over and over again. When I put it on DVD, people can get my DVD. And the good thing about DVDs is, you know, you can play back and play a section back if you missed it, or because there's so much information. I don't think you should be discouraged, though, because there's so much information. I know people don't want to have to live the life of a lawyer. On the other hand, we have to learn how to defend ourselves in court. We don't learn that. And you're going to depend on some lawyer. Well, you may not be all that happy with what you get. We in the movement here are fortunate in that we have some lawyers in our movement now that are pitching in and really helping out, helping our groups. And that's encouraging. I'm very appreciative of those gentlemen. I've gotten some emails with some very good information from one particular lawyer in particular. It's been very helpful. They signed the Patriot Act, these people we elected to Congress. I watched the debate on public television by two congressmen during that, while they were debating that. And they were debating, they were playing good cop and bad cop. The bad cop was a guy that was saying, the Patriot Act will allow the government to rummage through your house while you're gone for a period of 30 days without getting a search warrant. The good cop was saying, oh no, we should only allow the government to rummage through your house while you're gone for 10 days. I couldn't believe my ears. These are two congressmen that are sworn to uphold the Constitution. What happens to has to happen before a search can be done on anybody's house? Well, there has to be probable cause, and it has to be an oath statement sworn by somebody that there's probable cause for that search. And then the judge has to sign the search warrant. And when the agents come to your house, before they come in and search, they have to present that warrant to you. If they come to my house and say, we want to search something, I want to see that search warrant, otherwise you don't come across my door, threshold. I'm not threatening violence, but I'm going to stand there. You don't come in my house, you bring a search warrant, signed by a judge, accompanied by oaths, and I'll let you in. I don't, we're in a very, very difficult situation these days. I went in the military in 1954 till 1958, and I was proud at that time to serve my country. I knew I could die in the military. I knew that it was a dangerous place. We were in planes. We were around situations where things could explode and blow up. And I knew, and all of us guys understood, and we were willing to do it because we thought that we were fighting for probably the best nation in the world. And probably in 1954, it was pretty close to that. It ain't today. This is Soviet Russia. We've got a gulag. We have people in prison who are tortured by our people. I watched a television show on the torture that they did to Iraqis and detainees. And I'm frankly, I'm just appalled that Bush can get up there and say, we don't torture people, and then redefine the word torture, as though it's not torture to have a man shackled from the ceiling by chains like this for 48 hours straight with a bag over his head where he can't sleep. That's not torture to Mr. Bush. And Mr. Cheney, he thinks that's perfectly all right. And who's the other guy? Rumsfeld, Rummy. And Condoleezza Rice, she runs around saying how wonderful we treat prisoners. That's another issue, but we are in a very dire situation when our country can do this to people. I don't care if they're enemies. You don't do that to people. Well, the I hate to focus on that bad news, but probably I got to get it off my chest right now. The good news is we are growing in strength. Our whole movement is growing in strength every day. And these criminals that run our government, they know it. We do have good people in government, though. And they have been in a minority, and they're threatened. When they try to do the right thing, they're tossed out, they're maligned, they're, segregated. They have sanctions put on them. I get horror stories from people all the time about people getting sanctioned now in court for anything. Just from speaking up and asking questions. Look what happened to Irwin Schiff. I am running for Attorney General of the state of Michigan, and that will be this November, this election. The Constitution Party asked me to run, and I gladly said yes. I ran for Secretary of State the last election in Michigan, and I spent $400 on my campaign. You know how many votes I got for $400? 27,000. You know how much the winning Republican lady spent on her election or campaign? It was just over $1 million of her own money. She bought the campaign. You know how many votes she got? 1.2 million. So she spent about 90 cents a vote. I spent about 1/50th of a cent for all the votes that I got. So people are dissatisfied. They know what's going on. They're afraid. I talked to 3 people. I got in discussion with them on a train coming here, and one was a black gentleman. He was probably about in his late 30s. He had been in the Air Force 14 years. I talked to a Hispanic grandmother. She was in the conversation too. And the other lady was a lady who had graduated from high school, and when she graduated, she couldn't even read at a first grade level. She says, they just ramrodded me through the system. Bang, out the other end. I didn't know how to read. I didn't know how to do anything. She said, I learned about phonics. I learned how to read. I can read now at a 6th grade level, she says. That's pretty good. You know what? Next year she'll be at a freshman level. And if she keeps up. She's a very determined lady. The interesting thing was that the 4 of us, as we talked, when we got around to taxes and what's going on in the government, every one of them expressed great fear of our government. Is this what we instituted our government for? So everybody can live in fear of our government? Is this what we institute our government for, to take away our right to work at any job we want to work without let or hindrance, as Butchers Union says? Butchers Union was a Supreme Court case. Supreme Court says that the poor man's patrimony is his right to work. It's inviolate. It must not be a permission or a let from government. Butchers Union, 1884. And then there's Myers versus Kansas State in 1924. It was about 10 or 12 years after the 16th Amendment. Still saying the same thing. Myers versus Kansas. And Copage was another one about after the 16th Amendment was passed. So the Supreme Court was still saying after the 16th Amendment was passed that every man has a right to work. and it cannot be hindered or violated. And then the issue of the 16th Amendment always comes up. And I've heard, I don't know, we're doing the best we can to get this information out. I have a report that I did. It's called my 28-page report. Let's see if I have it here. I should have it here. Anyway, it's a 28-page report on liability. And what it has in it is the Supreme Court rulings on the 16th Amendment. So if you just read the 16th Amendment on the face of it, it seems to say a certain thing. It seems to delete or overrule the two clauses in the main body of the Constitution. Those two clauses say what? No direct tax may be imposed without apportionment. And the other one says representatives and direct taxes shall be imposed by apportionment on the states according to the enumeration of the census. That's one of the reasons why we have the census every 10 years, to count heads, so that representatives can be apportioned. The number of representatives may increase or decrease in a state. And direct taxes have to be apportioned the same way among the states. I think there were probably 2 instances of direct taxes being apportioned on people. It was well over 100 years ago. And that made a direct tax legal, constitutional, when it was apportioned. In Brewshaber, I wish I could find that offhand. I wish I could find that 28-page report, and I don't see it here. Oh, here it is. Here it is. Brewshaber is a case that the government uses to try to support its claim that the 16th Amendment overcame Pollock in 1884. Well, Pollock ruled a whole bunch of things, and I went through the whole Pollock case. But there's all kinds of things, like for instance in Pollock, that's 1895. Nothing can be clearer than that what the Constitution intended to guard against was the exercise by the general government of the power of directly taxing persons and property within any state through a majority made up from the other states. Well, in Butcher's Union, just prior to that, the court had ruled that your labor is your property. And it also said it's inviolable. So that was the law of the land until the 16th Amendment. Then the 16th Amendment, whether you want to admit that it was passed or not, that issue to me is really a moot point, because the 16th Amendment, in the wake of the 16th Amendment, there was a whole raft of cases in which the Supreme Court addressed the 16th Amendment. In 1913, in Stratton's Independence, it said property which, considered by itself, was not taxable. That's on page 417 of Stratton's Independence. In 1911, prior to that, it was property which, as such, could not be directly taxed. That's what it said. Now, the 16th Amendment, I'll read you that so you can know what the 16th Amendment actually says. The Congress shall have the power to lay and collect taxes on incomes. Incomes, remember that. From whatever source derived without apportionment among the several states and without regard to any census or enumeration. Okay, in 1916, Bruchaber was ruled. And let me read this because this is very clear, because they recognized that there was an apparent conflict between the main body of the Constitution and the 16th Amendment. The contentions under it, the 16th Amendment, if acceded to, would cause one provision of the Constitution to destroy another. That is, they would result in bringing the provisions of the amendment exempting a direct tax from apportionment into irreconcilable conflict with the general requirement that all direct taxes shall be apportioned. This result, instead of simplifying the situation and making clear the limitations on taxing powers, would create radical and destructive changes in our constitutional system and multiply confusion. Well, if the government of today would look at the rest of Pollock and what the Bruchaber and the other cases said, there wouldn't be the confusion. In in the 1954 House discussion on the Code section 61A of the 1954 Internal Revenue Code, it states, this definition is based upon the 16th Amendment and the word income as used in its constitutional sense. So now we have the word income used in two different senses. One's the constitutional sense, and one's the ordinary sense. And then it says this section corresponds to section 22A of the 1939 Code. Well, okay, the recognition in 1954 that code section was based on the 16th Amendment as it was used in its constitutional sense. And the word income is based in the constitutional sense. In 1913, U.S. versus Whitridge, it says, it was enacted in view of the decision of this court in Pollock versus Farmers, which held that the income tax provisions of a previous law to be unconstitutional because amounting in effect to a direct tax upon property within the meaning of the Constitution. There we go, within the meaning of the Constitution. And because not apportioned in the manner required by that instrument. In other words, it's the Constitution. So Whitridge just simply reaffirmed that. But the Bruchaber one is particularly good because as you read down through Bruchaber, you come to a kind of a long paragraph. I'll read you the two pertinent parts to that long paragraph. And this was 3 years after the 16th Amendment was passed. The court concluding that the classification of direct was adopted by who? The framers. Was adopted. This classification of direct taxes was adopted by the framers for the purpose of rendering it impossible to burden by taxation accumulations of property, real or personal, except subject to the regulation of apportionment. So here's the Supreme Court again stating that that was the purpose that the Pollock and the classification of direct taxes was made by the framers of the Constitution. It went on further, and it said, it was held that considering the substance of things, it was direct on property in a constitutional sense, since to burden an income by a tax was, from the point of substance, to burden the property from which the income was derived, and thus accomplished the very thing which the provision as to the apportionment of direct taxes was adopted by the framers to prevent. It was adopted, that classification was adopted by the framers to prevent a direct tax without apportionment. In other words, then the Supreme Court we have about 9 cases that say that the 16th Amendment didn't change anything, didn't do anything. There were no new subjects brought under the taxing power of the federal government. That was one of the statements that they make. And the other statement was there was no new taxing powers brought to the federal government by the 16th Amendment. And there's about 10 of those. So the Supreme Court was not confused. It knew exactly what it was talking about. Well, what was the word income then? Well, how could the Supreme Court rule that when the 16th Amendment appeared to make a difference to those 2 clauses in the main body of the Constitution? No direct taxes without apportionment. How could the Supreme Court rule that and have any consistency? Well, a lot of people have argued in the past that the Supreme Court was confused. No, it wasn't. Knew exactly what it was saying. The reason why it could say that there was no new taxing powers brought by the 16th Amendment was because of the definition of the word income. What was authorized before the passage of the 16th Amendment? Ask yourself that. What was authorized before? The only thing that was authorized was the Corporate Excise Tax Act. That was it. That was authorized in 1909 by it was ruled in 1909 by the Supreme Court that tax passed the constitutional muster. It ruled that because it was not a tax on the corporation's income, and that it was in fact a tax on the corporation's privilege of becoming a corporation, because a corporation derived a benefit from incorporation. And therefore, the courts ruled that the corporations ought to contribute to the government because of that benefit, because of the government conferred benefit. And that's stated in a lot of these cases. So before the 16th Amendment was passed, if you just think about that, the corporation income tax was permitted, and it was constitutional according to the Supreme Court. But that was all that was permitted. A tax was not permitted on a private company, mom and pop store, somebody going to work. In fact, in the Larkin Rose case, the lawyer actually admitted that to the government. That was just a couple of months ago. In the arguments before the court, the DOJ attorney argued, well, before the 16th Amendment was passed, no, you couldn't impose a tax on an individual's earning. He said, but the 16th Amendment changed all that. Larkin Rose should have objected right there and pulled up these 10 cases where the Supreme Court says, no, 16th Amendment didn't authorize any new taxing powers. I don't know what would have happened. The judge seemed to be fairly reasonable and fair in that case. I don't know what he would have done if that had been brought up. But the question is, the follow-on question is, well, why does not the 16th Amendment authorize a new taxing power? Okay, Supreme Court says it doesn't authorize new taxing power. Well, why? Because of the definition and the scope of the word income. And I have quite a few cases on the word income. And it's really okay, here it is. Here's one of them, 1918. Whatever difficulty there may be about a precise and scientific definition of income, it purports, as used here, something entirely distinct from principal or capital, either as a subject of taxation or as a measure of the tax. And this is the important part. They have a semicolon. conveying rather the idea of gain or increase arising from corporate activities, not from private activities, not just corporate activities. Because the corporation, when a company applies for the corporate status, they obtain a government-conferred benefit. And that benefit puts them into the category of income. And if they're going to say anything about the 16th Amendment, they have to talk about it in the constitutional sense. The constitutional sense and the scope of the word definition of the word income is a corporate gain arising from corporate activities, but it's not a tax on the incomes or the corporation's income. It is a tax on the privilege of incorporation only measured by the income, the size of the income of the corporation. So we've been scammed for 60 years. And when I went in the service, I didn't know this. We didn't have the internet. We couldn't research things. It was really hard. But the internet came along in the late 1990s, and all of a sudden, boy, we could research. And how much time? All right. So we had all this ability to do something we couldn't do prior to this. The internet is a great tool. It's not only a communications tool, but it's a research tool. Also, I've done two other things besides all these cases that I present in my 28-page report. There's a ton of cases here. Flora versus U.S. 1960, Stanton versus Baltic Mining 1916, Brushaber 1916, Taft versus Bauer 1929. That's 16 years after. Now let me read quickly what Taft versus Bauer says. Under former decisions here, now listen to this, the settled doctrine is that the 16th Amendment confers no power on Congress to define and tax as income without apportionment something which theretofore could not have been properly regarded as income. So it's saying before the 16th Amendment, if it couldn't be taxed before the 16th Amendment, it can't be taxed after the 16th Amendment because there was no new power conferred on Congress. This is 13 years after. Taft versus Bowers. By the way, I had a note. Somebody sent me this. Taft, Robert Taft, I think it was Robert Taft, or I don't know. Free of the presidency, served as professor of law at Yale until President Harding made him the Chief Justice of the United States in 1921. So this decision was 8 years after he was Chief Justice, or during his time. A position he held until just before his death in 1930. Taft was the Chief Justice during Taft versus Bowers. Taft was also the president who signed the legislative intent of the 16th Amendment and the corporate income tax on June 16, 1909 to the Senate. He was the one who presented that legislative intent to the Senate. And that was that 1909 corporate excise tax that I told you about that was authorized before the 16th Amendment was passed. He was the one. The income tax was to be levied against the national government, federal government. He was in a unique position to state that the 16th Amendment confers no power upon Congress to define and tax as income without apportionment, because he was the one responsible for the 16th Amendment legislative intent himself. He was the guy. So he had been involved in the whole thing with the 1909. There's a whole bunch of other cases, and I could go into that, but there's no point. I have two other arguments, standalone arguments on this besides the court cases. Okay, one is the statutes and regulations argument. Whenever somebody tells you that there's a law that says you're required to do this or that, there has to be a regulation, an implementing regulation that spells out who is liable, who has to do this, what has to be done. There has to be a regulation. You will find in the Internal Revenue Code where there's no implementing regulation for a lot of the statutes. And you can find that, generally speaking, on the table of parallel authorities, which is updated 2 or 3 times a year by the government itself. And the table of parallel authorities lists 2 columns down, and it will say for each code section of Title 26 and all the other titles, it'll cite on the other side across the line, will cite the implementing regulations. If there is no implementing regulation, then the code section is simply a benign statute. The Congress tells us this every year in a paper they put out. They tell us this every year. Only you didn't listen last time they said this, didn't you? It's a very long paper, but they put it out every year, and it's signed by a congressman. And basically it says, the legislature passes laws. Not bad, first start. It's not the Secretary of the Treasury, it's not the Internal Revenue Service that passes law. It's Congress, period. There are only 2 bodies in any state that will pass laws that apply to you. One is the Congress of the United States, and one is your state legislature, not your township. Townships adopt law. But if the paper goes on to say, it is up to the Secretary of the Treasury or the Secretary of Commerce to enact regulations that implement the law that Congress passes. Because Congress cannot enforce a law that they passed. They're not an enforcement body. That's part of our separation of powers. They can then ask the Secretary of Treasury or whoever to pass a regulation. The funny thing is the Secretary of the Treasury doesn't pass a lot of regulations that the IRS claims they have the power to do. If you want to take a little note, look in Title 26, which is the Internal Revenue Code, and look at the definition of employee in Section 3401. It only refers to employees of the federal government and corporate officers. So elected officials, employees, and officers of the United States. And the political subdivision. It doesn't say private employees working for private employers. And that is the definition on which the W-4 form hangs on. Every company thinks that they must have a W-4 on file for every employee that they have. Wrong. Do we have a buzzer that we can go, bar? Wrong. That's wrong. But see, that's another whole standalone argument. Then there's one other research I did it took me 5.5 months, and I was really intent on that. And that was the statutes at large. The Internal Revenue Code has not been passed into positive law. It is stated so in the titles. And in order to have the status of actual law, the code section must have a statute at large to back it up. So all you need to do, theoretically, is ask the judge, well, where's the statute at large for the Internal Revenue Code section? The judge will say, I don't have to give you that. One fellow went in the court and claimed that, and the judge says, well, I don't have time to research the statutes at large. And finally the court ordered the guy, he said, well, look, you have to get a private research company. Or no, the guy went to one of the government agencies, federal, anyway, one of the big agencies, and said, can you research this statute, this code section, and find me the statute at large? We don't have time to do that. And then you'll have to get a private person to do that, or a private company to do that for you. They can research it for you. So I went and did it. 6331 is the code section that they say authorizes them to levy on private employees working for private employers. 6331 of Title 26. There is no statute at large. That was what my research came out. There is no statute at large that authorizes the federal government to levy on a private employee. If the IRS or the government can come up with a statute at large, let me know. I'm willing to listen, but it ain't there. I can guarantee you about 99.5% that it ain't there. I would have really had to miss something. I spent 5.5 months on that. So that is our third standalone argument, and basically with that, I think I'll end the talk, and I really have been pleased to be here. I hope maybe Payman will invite me back next year if we have another one. It's been very, very pleasant to enjoy the company of all of you. Sometimes I get a little busy and sometimes a little, short, but it's not because I don't appreciate you all. I do. Okay, well, as I tell my logger, time to soap up your saddles, mount up, ride out, and make sure you're facing in front of the horse.
Thank you, Chuck. Appreciate that. We're fortunate to have people like Chuck Conces who are willing to dedicate themselves on a full-time basis to educate and empower people to take our freedoms back and take our country back.